My lady, before I come on to Henderson, I'll just hand in copies of Al Hassan Daniel and another and Revenue and Custom Commissioners, the case referred to by my Lord Justice Underhill.
Yes.
Thank you very much.
And the case reported in the 2011 Queen's Bench reports at 866.
If it's just to satisfy my curiosity, unless my ladies want to,
Then I shall leave it.
I can look at it later. Thank you.
Thank you. My lady, I was about to turn to Henderson and Dorset Health Authority, which is at tab 22 of the bundle on page 794.
Although I can't help noticing, I won't stand just before. It looks as though Clunis went to Strasbourg.
Do you know, I think I'd forgotten that.
There's a reference to Clunis against.
I don't think it met with success.
Is it the same case?
No. Yes, the application was rejected.
Yes, I see. Very well. Sorry, forget that. Yes, Henderson.
Henderson, and we have here the report from the first volume of the Weekly Law Reports in 2017 at page 2673. And essentially, the facts of Henderson were in all material respects indistinguishable from those of Gray, save that the judge in Henderson, Mr. Justice Foskett, expressly recorded when sentencing Ms. Henderson for the killing of her mother that he took the view that she should be regarded as not bearing any significant responsibility for that killing, and that and he decided not to exercise his powers that were available to him under Section 45A of the Mental Health Act to include a penal element in her disposal. Instead, he sentenced her under Sections 37 and Section 41 of the Mental Health Act.
I'm sorry, I should be familiar with this from the statutes you took us to at the beginning. What exactly does she mean by a penal element in the disposal? How would you recognise that they'd done that?
Well, they could do a combination under Section 45A, and I'm sorry, it's our failing because we haven't put it in the bundle, I think. You could have a situation where somebody goes to hospital for treatment for a certain period and then also then spends a certain amount of time in prison.
They can then be administratively transferred if their condition improves.
Yes. My lady knows the answer then.
Yes, and I'm sorry, it is our fault.
Yes. Okay, thank you.
Included Section 45A in the material. And the court, of course, not unnaturally considered Gray, and it was looking at Gray and Thames trains afresh following the decision of the Supreme Court in Patel and Mirza. But the first issue which arose was whether Gray was distinguishable in the first place because of that finding of lack of personal responsibility. I'm not going to go through all the passages in Gray again, but can I draw your attention to how the Supreme Court summarised them at page 957, paragraph 58, where his Lord Hamblin, who gave the judgment, unanimous judgment of the Supreme Court in this case, said that so far as relevant to the present appeal, I would make the following observations on the judgments given in Gray, insofar as they relate to public policy. One, both the narrow claim and the wide claim failed on grounds of public policy. Two, all judges considered that the relevant policy in connection with the narrow claim was the need to avoid inconsistency so as to maintain the integrity of the legal system, the consistency principle. Three, Lord Hoffman did not consider that this applied to the wide claim, but held that a related policy did, namely that it is offensive to public notions of the fair distribution of resources that a claimant should be compensated, usually out of public funds, for the consequences of his own criminal conduct. I understand this to mean that allowing a claimant to be compensated for the consequences of his own criminal conduct risks bringing the law into disrepute and diminishing respect for it. Is an outcome of which public opinion would be likely to disapprove and would thereby undermine public confidence in the law, the public confidence principle. The public confidence principle is also applicable to the narrow claim. It is related to the consistency principle.
That doesn't, well, without, I have to read more widely, but it's like curious analysis because it doesn't refer to the fair distribution of resources, which one would have thought is pretty clear as to its meaning.
Yes.
And the characterization, the later characterization of it by Lord Hamlin just misses that out completely. But there we are.
Yes, I suppose it might be said to be included with the fact that he talks about the fair distribution of resources, that you should be, by the fact that he endorses that statement from Lord Hoffman, but as my lady says, he doesn't put his gloss on it.
Yes.
I think he does come back to it later in the judgment, actually, when he's looking at specific policy factors against allowing the claim. And he says that one of those factors is the position of National Health Service bodies in particular and their funding.
Yes.
The public confidence principle is also applicable to the narrow claim. It is related to the consistency principle, since one of the reasons the public would be likely to disapprove of the outcome is the inconsistency that involves between the criminal law and civil law. And then, although Lord Roger appeared to consider that the consistency principle did not apply to the wide claim, the policy reasons he gives for rejecting the claim reflect that principle. The reason a person cannot attribute to others acts for which he has been found criminally responsible or seek rebate of the consequences of those acts is that it would be inconsistent with the finding of criminal responsibility. And if a person has been found criminally responsible for certain acts, it would be inconsistent for the civil courts to absolve that person of such responsibility and attribute responsibility for the same acts to someone else. And whilst the consistency principle more obviously applies to the narrow claim, on analysis it applies to the wide claim as well. In relation to the narrow claim, the inconsistency is with both the criminal court's finding of responsibility and the sentence it has imposed. In relation to the wide claim, it is with the former only. And then he goes through Clunas and he goes through Patel, and at paragraph 76 on page 962, he says that Patel concerned a claim in unjust enrichment, but there can be little doubt that it was intended to provide guidance as to the proper approach to the common law illegality defence across civil law more generally. The cases it discusses include tort cases, such as Gray and Hunger and Allen, as well as a number of Commonwealth tort law authorities. The case of Hall and Herbert, in which particular reliance was placed, was a tort case. And Tinsley and Milligan, which was not followed, concerned trusts and property rights. At paragraph 99, Lord Toulson identifies the policy reasons for the doctrine of illegality as a defence to a civil claim. The approach set out in paragraphs 101 and 120 is expressed in general and unqualified terms. And thirdly, that does not mean that Patel represents year zero, and that in all future illegality cases it is Patel and only Patel that is to be considered and applied. That would be to disregard the value of precedent built up in various areas of the law to address particular factual situations giving rise to the illegality defence. Those decisions remain of precedential value unless it can be shown they are not compatible with the approach set out in Patel, in the sense that they cannot stand with the reasoning in Patel or were wrongly decided in the light of that reasoning. Lord Toulson made clear in Patel that the principles he identified were to be found in the existing case law. And then the court referred to a case in which my Lord Justice Underhill gave the judgment, Okadina and Chikali, as an example of that. And he said in employment law, the touchstone for the availability of the defence of common law illegality to employee claims has long been recognised as being whether the employee has knowingly participated in illegal performance of the contract, as stated in the Court of Appeal decision in Hall and Woolston. In Okadina and Chikali, that approach had been followed by the Employment Tribunal and the Employment Appeal Tribunal. It was submitted on appeal that this was inadequate, and that the matter should have been addressed by going through the Patel trio of considerations, the Court of Appeal rejected the submission that it was necessary for the tribunal on the facts of this case to carry out an elaborate analysis by reference to the particular factors enumerated. As Underhill LJ explained in his judgment in Patel and Mirza, Lord Toulson was attempting to identify the broad principles underlying the illegality rule. His judgment does not require a reconsideration of how the rule has been applied in the previous case law, except where such an application is inconsistent with those principles. In the case of a contract of employment which has been illegally performed, there is nothing in Patel and Mirza inconsistent with the well-established approach in Hall and Woolston Leisure as regards illegality cases. As Mr. Reid put it, Hall is how Patel and Mirza plays out in that particular type of case. Of course, I do submit it is of note that Lord Toulson isn't saying there that knowledge is the determinative factor in all cases. He's saying in that particular situation, it has been held to be a touchstone in that particular class of case. The Supreme Court went on to hold that Gray was not distinguishable from Ms. Henderson's case. And at page 963, paragraph 83, Lord Toulson said, although there does not appear to have been any specific finding by the trial judge in Gray as to the degree of his responsibility, I am prepared to assume that he was regarded as bearing a significant degree of responsibility. The difficulty for the appellant, however, is that the degree of responsibility involved formed no part of the reasoning of the majority. The crucial consideration for the majority was the fact that the claimant had been found to be criminally responsible, not the degree of personal responsibility which he reflected, or which that reflected. And the court then also rejected an argument that the approach in Gray couldn't stand with the approaches adopted in Patel. And at 964, paragraph 89, under the heading whether the reasoning in Gray cannot stand with the approach to illegality adopted by the Supreme Court in Patel, the appellant argues that the decision in Gray, this is paragraph 89, is an example of the now discredited rule-based approach to illegality and is contrary to the flexible policy approach endorsed in Patel. It does not allow the court to take into account the particular circumstances of the case, such as the degree of the claimant's personal responsibility, nor does it allow for consideration of proportionality. In my judgment, the essential reasoning in Gray is consistent with the approach adopted in Patel. Gray did not involve the reliance-based approach, nor did it follow or apply Tinsley and Milligan. Indeed, at paragraph 30 of his judgment, Lord Hoffman stated that such an approach was not helpful in that case, that it had nothing to do with whether there is a rule of law for which the appellants contend, and that the maxim extirpa causa expresses a policy. The court in Gray examined whether the narrower and wider rules were, as contended, a special rule of public policy. As already explained, both Lord Hoffman and Lord Roger considered the policy reasons for the rules and concluded that they were justified as a matter of public policy, even though Lord Hoffman endorsed a causation approach to the application of the wider rule that involved a causal rule based on policy considerations. As the Court of Appeal said in its judgment, it was a combination of public policy and causation. The court then finally rejected an argument that Gray should be departed from, and that's at 965, starting at little Roman numeral 2 at the bottom of the page, whether it should be held that Gray does not apply where the claimant has no significant personal responsibility for the criminal act and or there is no penal element in the sentence. And the court set out the arguments that Ms. Henderson made in that respect. At paragraph 98, the appellant's fundamental point is that there is no inconsistency or incoherence between the civil and the criminal law in a case in which the claimant has no significant personal responsibility for an act. And then at paragraph 100, given what the appellant says is the satisfactory state of the law governing criminal responsibility, it is submitted that no incoherence would be introduced into the law if tort law was to adopt a different approach to responsibility. It is pointed out that in any event, civil law approaches issues of responsibility differently, focusing more on the question of capacity. Moreover, the purposes of the criminal law focusing on the person's wrongdoing, and tort law, the connection between the wrongdoing and the claimant's injury are different. And given the divergent functions of tort law and the criminal law, it is submitted there's nothing incoherent or inconsistent about tort law and criminal law having different tests for responsibility. And then at paragraph 101, reference to no inconsistency to be further borne out in this case by the fact that the sentence imposed involved no penal element. Sentence under the 93 Act only contains a penal element if an order under section 45A.
That's the answer to my question.
Yes. And the judge has to make an assessment of culpability to do that. And the judge in this case declined such an order precisely because of the appellant's lack of significant personal responsibility. And the court rejected those arguments at paragraphs 105 to 109, and that's page 967 of the bundle. As explained above, the key consideration as far as the majority in Gray was concerned was that the claimant had been found to be criminally responsible for his acts. That he had been convicted of manslaughter on the grounds of diminished responsibility meant that responsibility for his criminal acts was diminished but not removed. It was not an insanity case, and so, as Garnham LJ pointed out in Clunas, he must be taken to have known what he was doing and that it was wrong. In such circumstances, the majority in Gray justifiably considered that inconsistency would arise not only if he was allowed to recover damages resulting from the sentence imposed, but also if they resulted from the intentional criminal act for which he had been held responsible. To allow recovery would be attribute responsibility for that criminal act, not as determined by the criminal law to the criminal, but to someone else, namely the tortious defendant. There's the contradiction between the law's treatment of conduct as criminal and the acceptance that such conduct could give rise to a civil right to reimbursement. The criminal under the criminal law becomes a victim under tort law. Whilst the Ryder rule may not involve, as the application of the narrower rule does, the law giving with one hand what it takes away with the other, it does involve the law condoning when facing right, what it condemns when facing left. If, as the appellant submits, the degree of responsibility is a matter for the trial judge to determine in the civil claim, then there's a clear risk of inconsistent decisions being reached between the criminal and the civil courts, both as to degree of responsibility involved and as to how that is to be determined. If, as is further submitted, it is appropriate for the civil court to move away from the Norton approach to insanity and develop its own approach to such issues, then the inconsistency will be heightened, nor does the fact that there may be no penal element to the sentence imposed by the criminal court alter matters. As Lord Rogers observed in Gray, even if the sentence is not regarded as being a punishment, this does not mean the judge was treating the claimant as not being to blame for what he did. A conviction for manslaughter still involves blame. The defendant would otherwise have been convicted of murder, and some responsibility for the unlawful killing necessarily remains. Moreover, the fact of a criminal conviction for manslaughter itself is punitive. Now, of course, the Supreme Court here, crucial to its reasoning in this case, was that element of criminal responsibility. And it rejected an argument that the claimant should be approached on the basis that she bore no criminal responsibility. However, what it did not decide was what the outcome would have been had in fact it accepted the argument that she bore no criminal responsibility due to insanity. It did not need to go that far. As she was asking the court to go behind the criminal finding of insanity, the appellants in this case are not asking the court to go behind the criminal finding of insanity. Our submission is that that finding and the resulting disposal are themselves sufficient to engage the illegality defence. At paragraph 112, his lordship dealt with the issue of a final argument on turpitude, where he said, finally, the appellant, this is on page 968, he said, finally, the appellant advances a related argument that the lack of significant personal responsibility means that there is insufficient turpitude to give rise to an illegality defence. This, again, ignores the seriousness of a criminal conviction for manslaughter. It is an indictable only offence punishable by way of life imprisonment. It is a serious offence for the purposes of provisions regarding dangerous offenders in the Criminal Justice Act 2003, and that's what I mentioned earlier in relation to the MAPA requirements. Similarly, those who are acquitted on the basis of insanity for murder are treated as dangerous offenders under that act. The plea of guilty to manslaughter by reason of diminished responsibility means acceptance by the appellant that she possessed the mental prerequisites of criminal responsibility for murder, namely an intention to kill or to cause grievous bodily harm. In the present case, the expert psychiatrist also agreed that the appellant knew what she was doing was morally and legally wrong when she inflicted the stab wounds. In a laboratory survey on Apotex, Lord Sumption stated that the paradigm case of an illegal act engaging the defence is a criminal offence. As Lord Sumption explained, there may be some exceptional cases where a criminal act will not constitute turpitude. The reservation made in Gray in relation to trivial offences may be an example of such a case, as may be strict liability offences where the claimant is not privy to the facts making his act unlawful. But the serious criminal offence of manslaughter by reason of diminished responsibility does not come close to falling within such an exception and clearly engages the defence. The court then turned to an application of the Patel criteria, and at B69, page 969 of the bundle, paragraphs 115 to 116, and this was a point I was rather inelegantly making this morning in response to a question from the court. But firstly, at paragraph 115, the appellant contends that the case should be remitted so that evidence can be adduced as to the suggested policy considerations, as to which there were various factual disputes. It is neither necessary nor desirable that consideration of the relevant policy considerations should give rise to a mini-trial. They should usually be capable of being addressed as a matter of argument and at a level of generality that does not make evidence necessary, as is well illustrated by this court's decision in Hunger and Allen.
I'm not quite sure I understand the first sentence of that. Evidence can be adduced as to the suggested policy considerations, as to which there were various factual disputes. Did Lord Hamlin mean that there should be evidence which went to the various policy considerations? Yes. I presume that's what he meant.
I think the
not
suggestion...
Not about what the policy considerations might be.
I think the suggestion from the appellant was that there needed to be evidence to be adduced about the policy considerations, whereas Lord Hamlin was saying, well, actually, no, because it's a matter of judicial policy, essentially.
Well, things like cost to the health service and that sort of thing.
Yes, things like cost to the health service, I suppose. Or,
but not as to the underlying facts of the case.
No, he wasn't dealing with that here, he was dealing with policy. And he said, secondly, questions arise as to exactly how, under the trio of considerations, approach relevant policy considerations are to be weighed. It appears that this must involve a balancing between considerations arising at the first and second stage. The third stage relates to proportionality and factors specific to the case rather than general policy considerations, which may tie with my lady's point just now. Stage A is directed at policy reasons which support denial of the claim, and Stage B is directed at policy reasons which support the denial of the illegality defence. As Lord Toulson makes clear, Stage B is meant to operate conversely to Stage A. And at paragraph 119, he said that it follows that stage A should not be interpreted as being confined to the specific purpose of the prohibition transgressed. Whilst that is, of course, of great importance, other general policy considerations that impact on the consistency of the law and the integrity of the legal system also fall to be taken into account. In the present case, for example, that would encompass the public policy considerations identified in grey, namely the consistency principle and the public confidence principle. Similarly, while preventing someone from profiting from his own wrongdoing is not the rationale of the illegality defence, it is a relevant policy consideration which is linked to the need for consistency and coherence in the law. For one branch of the law to enable a person to profit from behaviour which another branch of the law treats as being criminal or otherwise unlawful would tend to produce inconsistency and disharmony in the law and so cause damage to the integrity of the legal system, as recognised in Patel. In cases where it features, it too is a factor to be taken into account, even though it may not reflect the purpose of the prohibition transgressed. In considering the issue of consistency and coherence in the law, the closeness of the connection between the claim and the illegal act may well be of relevance. The closer that connection is, the greater and more obvious may be the inconsistency and the consequent risk of harm to the integrity of the legal system. The rejection by the majority in Patel of reliance as the test of illegality did not mean that reliance was thereby rendered irrelevant to the policy-based approach. It may not provide a satisfactory test of illegality, but will often be a relevant factor. And thirdly, questions arise as to the weight it may be appropriate to give different policy considerations. At paragraph 99, Lord Toulson recognised the importance of the policy considerations that a person should not be allowed to profit from his wrongdoing and that the law should be coherent. Where either of these considerations are engaged, it would seem appropriate that they are given great weight. This was the point made by Lord Kerr in his judgment at paragraph 143, where he stated as follows: Lord Toulson's solution to this question also permits readier access to investigation of the traditional justifications for the ex turpi causa maxim.
Are you saying that claim for damages in this case would be a profit for this purpose?
No, and because clearly it's, strictly speaking, it's a claim for compensation.
Right.
No, I think, but Lord Toulson seems to be, or sorry, Lord Hamblin seems to be saying here, and it's the same in Henderson's case, she was seeking damages for compensation. But nonetheless, irrelevant factor is...
To obtain a benefit.
Yeah.
That perhaps might be rather than a profit.
Yes, might be a better way of putting it. And then at paragraph 124, in relation to proportionality, Lord Toulson identified 4 factors which were likely to be of particular relevance, namely the seriousness of the conduct, its centrality to the transaction, whether it was intentional, and whether there was a marked disparity in the parties' respective culpability. Lord Toulson refrained from saying anything about potential weight of such factors, no doubt to avoid being prescriptive. I would, however, suggest that centrality will often be a factor of particular importance when considering the circumstances relating to the illegality, whether there is a causal link between the illegality and the claim, and the closeness of that causal connection will often be important considerations. And I do, of course, draw attention here to the fact that, like Lord Toulson, his lordship placed knowledge and intentionality as one of the factors to be considered, rather than, as the judge below sought, as a determinative factor. At page 971, his lordship then applied stage A, and at 125 he said, as explained above, this stage involves identification of policy reasons which support denial of the claim and considering first general policy considerations rather than the purpose of the prohibition for the reasons explained in grey. The consistency principle is engaged in this case. there is a need to avoid inconsistency to maintain the integrity of the legal system. While that most obviously applies to the narrower rule, it also applies to the wider rule. As Patel makes clear, this is a central and very weighty public policy consideration. For the reasons given by Lord Hoffman in Gray, the public confidence principle is also engaged. And then this may bring it back to Lord Hoffman's point about distribution of resources, because at 127, he says, in the present case, the gravity of the wrongdoing heightens the significance of the public confidence considerations, as does the issue of proper allocation of resources. NHS funding is an issue of significant public interest and importance, and if recovery is permitted, funds will be taken from the NHS budget to compensate the appellant for the consequences of her criminal conviction for unlawful killing. And then he said it's also a case where there's a very close connection between the claim and the illegality, thereby highlighting and emphasising the inconsistencies in the law which would be raised were the claim to succeed. The appellant's crime was the immediate and on any view effective cause of all heads of loss claimed. Indeed, applying Lord Hoffman's approach to causation in Gray, with which Lord Roger and Lord Scott agreed, it was the sole effective cause of such loss. In relation to the underlying purpose of the prohibition transgressed, an important purpose is to deter unlawful killing, thereby providing protection to the public. As far as the public is concerned, there could be no more important right to be protected than the right to life. It is clearly in the public interest that everything possible is done to enhance protection of that fundamental right. There is also a public interest in the public condemnation of unlawful killing and the punishment of those who behave in that way. On behalf of the appellant, it is submitted that it is absurd to suppose that a person suffering from diminished responsibility will be deterred from killing by the prospect of not being able to recover compensation for any loss suffered as a result of committing the offence. Indeed, more generally, it is submitted that a person who is not deterred by a criminal sanction is unlikely to be deterred by being deprived of a right to compensation. There is force in these points, but the question should not be considered solely at the granular level of diminished responsibility manslaughter cases. Looking at the matter more broadly, there may well be some deterrent effect in a clear rule that unlawful killing never pays, and any such effect is important given the fundamental importance of the right to life. To have such a rule also supports the public interest in public condemnation and due punishment.
Just pausing for a moment, Mr. Warnock, the exercise that Lord Hamblin is going through here,
Yes.
which starts under at 113, as I understand it, under the heading whether the application of the trio considerations approach set out in Patel leads to a different outcome. In a sense, this is an unnecessary exercise, isn't it, given the conclusions that have been reached under Little Roman 1, Little Roman 2, namely that Gray is not overruled by Patel, and that it's not distinguishable.
I think your lordship may be right about that. It clearly seems
Well,
like
it has a practical consequence because it seems, my present thought is that it's inconsistent with the general message of Henderson and certainly of Gray that you should be having to do this exercise in a case of the kind to which Gray applies. There's maybe a separate question whether, about whether you need to do it in this case. But if there is a fundamental principle about inconsistency and public confidence, which is what underlies the reasoning in Gray, as explained in Henderson, you shouldn't have to do this exercise each time, should you? And COL go through all these various considerations.
I can certainly see the force in that, although he has done it, and it does help in a case like this, which is not decided, because what he's doing is he's essentially explaining why Gray is an application of the rules by analysing, demonstrating on the Patel approach how that outcome that is reached in Gray is reached. And it's certainly extremely helpful in a case like ours, which is not decided by any previous case in this jurisdiction.
Yes.
And indeed, Lord Toulson had said in novel cases that that's where the Patel approach would come into its own, essentially. It's a bit like in the law of duty of care with Robinson and the Chief Constable of West Yorkshire. If you've already got an established case, so then, unless it's clearly wrong in the light of the principles in that case, you stick with it. But if there's a case raising a point which is novel,
yes,
then you may have to go beyond that.
Thank you.
And he dealt with the countervailing policies, and I'll take these really briefly at paragraphs 131 to 132 to 137. But essentially, the first sentence sums up which each of the countervailing policies was. First, the policy of encouraging NHS bodies to care competently for the most vulnerable. His lordship didn't find that persuasive. Secondly, the policy of providing compensation to victims of torts where they're not significantly responsible for their conduct. So it's not clear that there was any such policy. The third is the policy of ensuring public bodies pay compensation to those whom they've injured. That's paragraph 135. And he said that begs the question. And the fourth is the policy of ensuring that defendants in criminal trials receive sentences proportionate to their offending. He said that's consistent with the purpose of the narrower rule, which is to avoid giving back with one hand, which is taken away by the other. I recognise there's force, at least in some of the policy considerations relied on by the appellant, but I do not consider that they begin to outweigh those which support denial of the claim. And then at C, in relation to proportionality, he said it was not suggested that there were factors relevant to proportionality aside from the four factors identified by Lord Toulson in Patel, namely the seriousness of the conduct, the centrality of the conduct, and whether the conduct was intentional, and whether there was a marked disparity in the parties' respective wrongdoings. And he said, as to the seriousness of the conduct, this was a very serious offence. It involved culpable homicide committed with murderous intent. As was acknowledged on behalf of the appellant, unlawful killing is the most serious conduct imaginable. The appellant knew what she was doing, and it was legally and morally wrong. As to the centrality of the conduct of the transaction, the offending is central to all heads of loss claims. And as to whether the conduct was intentional, there was intent to kill or to do grievous bodily harm. Whilst there may have been no significant personal responsibility, there was nevertheless murderous intent. And as to whether there was a marked disparity in the parties' respective wrongdoing, the appellant was convicted of culpable homicide. While she may not bear a significant degree of responsibility for what she did, she knew what she was doing, and that was legally and morally wrong. The respondent has admitted negligence in the appellant's treatment. It is not the case, however, that the respondent's staff did nothing in response to the appellant's mental health, and he concluded that denial of the claim would not be disproportionate. That was all I was proposing to take you through in Henderson before I turn to the New South Wales case, which has considered at this point of Hunter Area Health and President, which is reported in the New South Wales. It's 2005 New South Wales Court of Appeal 43, and it's at tab 41 of the bundle, page 1106.
Is this the only version in which it's available? It's quite difficult to read. It's in very small print, and there's a very intrusive hallmark. Isn't there just a more conventional law report?
I certainly think we should look into that. I don't know is the answer. My learned junior says they couldn't find one of
both my ladies are much younger than me, but I found it really quite hard going. So if there was a hard copy, a better copy, I'd be grateful.
My learned friend says that they had a better copy in Henderson, and she will see if they can find it to produce it for my lord. In the meantime, I fear I may have to just
of course
go on. But the facts were actually quite similar to the facts here. They appear in the head note at 1107. In essence, that the plaintiff, Presland, had been awarded damages at first instance for a psychiatrist discharging and failing to restrain him and care for him in circumstances where he was said to be at risk to himself and others as a consequence of mental illness. And 6 hours after he was released from the psychiatric hospital, he killed the fiancée of his brother, and he was acquitted of murder on the grounds of mental illness and was detained for a period in the psychiatric hospital until it retained under the New South Wales Mental Health Criminal Procedure Act. To all intents and purposes, he was found acquitted on the basis of insanity. The reasoning of the judges is helpfully summarised at page 1108. And Scheller J.A., who was in the majority, held that there was no difficulty in accepting that a duty of care was owed, but said that when Presland was acquitted of the murder on the grounds of mental illness, this is point 2, his act was and remained an unlawful act. The act was not justifiable homicide, but an unlawful homicide for which he was not criminally responsible. And then the damages sought were for the consequences of the killing. The result of those acts was that the plaintiff was lawfully detained in strict custody in the psychiatric hospital as a forensic patient until released by due process of law. Public policy must loom large in the court's consideration of whether the plaintiff should be compensated for the harm so suffered. And he held that it was not very recoverable. Santo J.A. Thought the duty of care did not extend to a decision not to detain the respondent. And he said no such duty could be derived from the Mental Health Act. But at holding 3 on page 1109, he said in terms of the normative aspects of causation, it would be unjust to render the appellants as defendants legally responsible for a non-physical injury traced back to unlawful but not criminal conduct. This is because it is excused but not justified by the law on the ground of the respondent's insanity. It nonetheless constituted wholly unreasonable action, though lacking moral culpability only by reason of his insanity.
So they're classified as causation. That's really public policy coming in by a different route.
Yes, it's fair to say that the judges in this case eschewed the notion that they were applying the ex turpi causa defence as they read it at the time. However, what they have done in terms of their reasoning is what we would now classically recognise as an application of the illegality defence post-Patel. And indeed, that's how Lord Hoffman viewed it in Gray. You may recall Lord Hoffman referred to this case and referred to it in terms of an application of the illegality rule, which, as he said, was a rule of public policy. So although they themselves don't label it as illegality, the reasoning we see is front and centre Patel-style reasoning. And if I was going to say Chief Justice Spiegelman dissented, although as I'll take you to in the judgment, even he thought it was too far to allow the claimant to recover damages for the period that he was actually detained. Go there. But can I first of all turn to Scheller's judgment at page 1179. And at paragraph 251, he summarised the judge's findings at first instance, where he said, according to Adams J, at the time the plaintiff was attacked and killed Ms. Laws, he was in a psychotic state, which so affected his capacity to reason that he did not know what he was doing was wrong, and accordingly he was not guilty on the grounds of mental illness. And then he said at the King and Porter, speaking of the necessary state of mind of disease, disorder or disturbance explained that being of such character as to prevent the accused from knowing the physical nature of the act he was doing. But the other head is quite a different one.
Well, that's just an Australian version of
That's
it.
just the Australian version of Norton. And then at 285 on page 1187, sorry, page 1186, bottom of page 1186. He said, I have no difficulty in accepting that the psychiatrist and through him Hunter owed the plaintiff a general duty of care of the sort described in Rogers and Whittaker's. I'm equally satisfied that if the plaintiff had been convicted of the murder of Ms. Laws, a claim based on loss and damage flowing from his subsequent incarceration would have failed. Now you refer to the Weagold case, and particularly the short dictum of LJ and Cleaver, a mutual reserve fund life association. In such a case, the plaintiff's intention to kill would have intervened to break the chain of causation. But that apart, either public policy or the policy embodied in the phrase ex turpi causa would have prevented recovery of damages. And then at 292 on page 1188, he said, in general terms, two considerations may stand in the way of the plaintiff's success in the present case. Although he was acquitted on grounds of mental illness, his act was and remained an unlawful act. His was not justifiable homicide, but an unlawful homicide for which he was not criminally responsible. By contrast, suicide or attempted suicide have not since 1984 been crimes in New South Wales. Adams recognised that the plaintiff's acts were deliberate acts of killing. His acquittal on the grounds of mental illness proceeded in the language of Dixon J. and Porter on the supposition that the plaintiff knew he was killing, knew how he was killing, and knew why he was killing, but that he was quite incapable of appreciating the wrongness of the act. Although the plaintiff was acquitted and hence held not criminally responsible for the murder, what followed for which he now seeks compensation was the statutory response to the reason for his acquittal, Section 39 of the Mental Health Criminal Procedure Act. He was accordingly detained in strict custody in a psychiatric hospital. He claims damages for the consequences of that detention.
Can you just unpick for me in what sense is it an unlawful act if it's not an act for which he is criminally responsible?
I suppose if one takes the definition of murder, which, setting aside that murder requires a person of sound mind, which is circular because that brings one back as to whether the person is insane or a child. The definition of murder is that the person of sound mind carries out an unlawful killing with malice aforesaid. So the definition of unlawful is actually in the offence.
It simply means a killing for which there was no lawful justification.
Yes, I mean, nobody
fine. I
could,
just wanted to spell that out.
Nobody could describe what happened to the gentleman in this case as a lawful killing.
No, but I wanted.
I mean, you have you can have a situation in which an ordinary acquittal means that the act committed was not unlawful.
Yes.
Or the defendant did not commit the act that was unlawful.
Yes.
So, for example, you might have a case of justifiable homicide, as described in relation to self-defense. But in a case such as this, where you have a choice between describing it as a lawful act or an unlawful act, it can't be described as a lawful act.
Quite.
And there's no interim.
No, and that's why I took the court to
Attorney
Attorney General.
Civil lawyer in me thinking that he's effectively saying it's a tort, but that begs the whole question. But I think the answer is, as you've given, as my lady has confirmed, it's simply in this context, it means a killing for which no lawful justification.
Yeah. And that's why I took the court to Attorney General's reference number 3.
Yes. No, that's fine. Thank
you. And then at paragraph 295, he said the following features assist in identifying the harm that the plaintiff here suffered. First, the plaintiff claims to recover damages because of the failure of the defendants to detain him when, according to his own evidence, he wished to be detained. And secondly, the plaintiff claims to recover damages, the consequence of his deliberate and unlawful killing of Miss Laws. The damages sought are for the consequences of those acts of killing. The result of those acts was that the plaintiff was lawfully detained in strict custody in a psychiatric hospital as a forensic patient until released by due process of law. Public policy must loom large in the court's consideration of whether the plaintiff be compensated for harm so suffered. And at paragraph 298 on page 11.
On the structure of this judgment, he says, in the first place, are we to read the following paragraphs as giving particulars of the public policy?
Yes.
Which he refers to in the final sentence.
Yes.
Yeah.
At paragraph 298 on page 1190, he said, the evidence in the present case demonstrates that the plaintiff was harshly, if not badly, treated as a forensic patient. There may be much to be said for the argument that a person so detained lawfully is entitled to better treatment and monetary compensation, but the detention and treatment of the plaintiff was that prescribed by law as a consequence of the unlawful killing of Miss Laws. Yet the damages awarded are similar to those which would be awarded as general damages if the plaintiff had been unlawfully detained. And at 300, he said, if in the present case, this is the remark Lord Hoffman referred to, if instead of killing Miss Laws, the plaintiff had come upon Dr. Nazarian that night and killed her in him, Dr. Nazarian's estate or Dr. Nazarian would, by parity of reason, have been liable to compensate the plaintiff for the consequences of his detention as a result of the unlawful killing or assault upon Dr. Nazarene. In this case, identification of the nature of the harm suffered by the plaintiff points as a matter of common sense against the existence of a legal responsibility in the defendants for that harm. And that was the remark that Lord Hoffman described as pertinent in the Gray case. And then at Santos J.A.'s judgment at page 1193, he said that the paragraph 312, he said the respondent's case needs to be considered with a fair appreciation of that fact to determine whether, at paragraph 311, he said what makes this case so unusual is that the action is brought not by the victim or the victim's relatives for the consequences they have suffered, nor is the plaintiff compensated for any physical self-harm. Nonetheless, the respondent undoubtedly suffered from other non-physical harm of a serious kind, following the hospital's failure to compulsorily detain him. It is for that harm he seeks to recover. The respondent's case needs to be considered with a fair appreciation of that fact to determine whether, in accordance with proper application of principle, he was entitled to recover from the appellants. I've had the advantage of reading the draft judgments of Spiegelman, CJ, and Scheller, JA. Spiegelman, CJ, rightly observes of his draft judgment that how society treats its citizens who suffer from mental illness, particularly the criminally insane, is often a test of its fairness. I would, however, add to paraphrase what was said by Mike Hugh in Cole and South Tweed's Head Rugby, some minds may instinctively recoil at the idea that a hospital authority and psychiatrist, however careless, may be liable for the loss of liberty lawfully suffered by a forensic patient following his killing of another while insane, itself an unlawful act, but without criminal consequence. Such an instinctive recoil is no substitute for the objective application of tort principle, as McHugh there points out. But that reaction may nonetheless be a reflection of more considered community values, not to be stigmatized as based merely on prejudice or emotion. As HLA Hart pointed out over 40 years ago, insanity is not a justification for an unlawful act of homicide, but rather an excuse. As an excuse, it reflects the fundamental moral principle that a person is not to be blamed for what he has done if he could not help doing it. HLA Hart, punishment and elimination of responsibility. The history of insanity as a defense to criminal responsibility by reason of absence of mens rea is illuminatingly set out in O'Brien J's judgment in RNS. But it does not follow that such a person as distinct from his victim should be compensated for the lawful consequences to him that followed the hospital's initial failure to detain him for treatment. And that is for two possible reasons. The first is grounded in legal policy, and the second relates to what would have happened if the supposed duty had been performed. Garnham J observed in Chapel and Hart concerning causation that the but-for test is not a comprehensive and exclusive criterion, and the results which are yielded by its application properly may be tempered by the making of value judgments and the infusion of policy considerations. So it may be unjust to hold a defendant legally responsible for an injury which, though it may be traced back to the wrongful conduct of the defendant, was the immediate result of the unreasonable action on the part of the plaintiff. While here the respondent was, by reason of his insanity, judged incapable of acting with the necessary intent, his act of homicide was an unlawful act, hardly to be described as constituting reasonable action. Without in any way relying on the extirpe causa maxim, I ultimately conclude that it would be unjust for the common law to allow the respondent a remedy for non-physical injuries he has suffered in these circumstances. I here respectfully differ from Spiegelman CJ's conclusion to the contrary. I do not base my conclusion on any moral culpability on the part of the respondent. Rather, I base it on what I conceive legal policy, ultimately based on community values, would consider just in such a case. So as I say, he said he wasn't applying ex causa as a maxim, but he certainly was, as we would view it, applying the illegality policy defence. And he then, at 1208, paragraph 383, page 1208, paragraph 383, he said, "While I agree that the unlawfulness of an act of homicide committed while insane should not be an automatic bar to recovery, I respectfully disagree that it is no weight when it comes to determining what the consequences of such actions should give rise to civil liability in negligence. Legal policy treats insanity as an excuse, though not justification, for what remains an unlawful act. According to Hart, the essence of an excuse is that the act may be deplored, but the psychological state of the agent when he did it exemplified one or more variety of conditions which are held to rule out public condemnation and punishment of individuals." And he cites, that's from punishment and responsibility cited in Jones.
He was obviously troubled by the causation issue, which I referred to earlier.
Yes. Well, he, like Lord Hoffman in his speech in Gray, had also viewed the illegality principle in part through the prism of causation, seeing it as essentially the policy factors playing out in causation in what he described as the wider consequences of the rule. But one way or the other, they are saying that the policy considerations bar the claim, because what we have here is an unlawful act, albeit an act for which the claimant isn't criminally responsible.
I don't quite understand what he's saying in this paragraph. He starts by conceding that it shouldn't be an automatic bar to recovery, but he goes on, if you unpick the double negative, saying it has weight. But that would suggest that he's suggesting some sort of case-by-case, matter of degree analysis.
Yes,
but the rest of the paragraph suggests an absolute rule.
It does, and the rest of his judgment is inconsistent with that. It may be that what he has in mind is, for instance, like in this case, we're not saying that the claimant couldn't get damages for any injury he'd suffered up until the point of the killing, so it's not a defence. It's not an automatic defence in liability as such, but it is of application to the heads of loss that are being claimed, because he very much here analyses it in terms of what is being claimed.
Or it could just be a cautious never say never.
It could just be that. Yes.
Sometimes this arises, we don't know.
And finally, I'll just draw the court's attention to his overall conclusion at paragraph 388. He said that I'm of the view it would be unjust to render the appellants as defendants legally responsible for a non-physical injury suffered by the respondent from deprivation of his liberty when traced back to the unlawful but not criminal conduct This is because that homicidal conduct is excused but not justified by the law on the ground of the respondent plaintiff's insanity. That conduct nonetheless constitutes wholly unreasonable action on the respondent's part, lacking moral culpability only by reason of his insanity. And he also said civil liability would risk bias towards detention. I said I'd go to one passage in Spiegel, Chief Justice Spiegelman's judgment, and it's in page 1127 of the bundle. And I said that even he, although he was in the minority in relation to many of the heads of loss, he would not allow damages for the detention. And at paragraph 100, he said His Honour had earlier set out Mr. President's experiences in this regard, including his fear of violence in the remand centre, restrictions on movement.
So where are you reading from?
100 on page 1127.
Oh, I see. Thank you, yes.
All of these were matters which arose from the lawful conduct of the authorities. In my opinion, the loss or damage he suffered in this regard is too remote from the tortious conduct of the appellants. There is a line of authority in wrongful imprisonment cases which award damages only up to the time of a lawful order which authorises imprisonment. See Locke and Ashton, Diamond and Minter. Diamond and Minter was a case of an arrest warrant wrongly executed by a constable, but the constable's liability for damages ended from the point that the individual was brought before the magistrate's court and then remanded. A similar principle could be applied in the determination for damages for negligence.
Interesting to see this from the top of the page, that the first instance decision, which allowed recovery, came in for a lot of media criticism.
Yes. I wasn't going to go there. My lady, against that background, I essentially have been touching on my submissions as I go through them, but can I then turn briefly in the time that's available to me to the judgment and the grounds of appeal? And for the judgment, one has to go to the main appeal bundle.
Yes.
And can I go straight to the judgment? Page 163 of the bundle. Judgment of Mr. Justice Garnham. And at paragraph 134, his lordship said that I accept that it is possible that the illegality defence could apply in situations where there is no criminal responsibility, but to do so there would have to be quasi-criminality, conduct that raises similar public interest objections to those prompted by criminality. That provides, to adopt Mr. Warnock's phrase, an adequate bright line rule, and there is no warrant for inventing one which disregards the necessity of establishing that the claim in question is based on a criminal act or one very similar in nature. The bright line in Henderson would not be undermined if this claim were to proceed.
You needn't worry about reading out the passages. We've all read the judgment.
I'm grateful, thank
So
you.
can
The
read
point I make in relation to this paragraph is that having accepted that the illegality defence could apply where there's no criminal responsibility in the first sentence of it, by the time we get to the end of it, it seems to all turn on the presence or absence of criminal responsibility. And the judge, having acknowledged correctly that it could apply in cases where there is no criminal responsibility, but quasi-criminality, in other words, almost or nearly criminality, we submit in our skeleton, and it's our ground one, that it's hard to imagine a clearer example of a quasi-criminal act than the acts we are dealing with in this case. involving 3 killings of members of the public.
This is playing with words, isn't it? I mean, the concept of a quasi-criminal act appears in Lord Hoffman's speech in Gray, I think, or perhaps it goes back before that. It's Lord Sumption.
It's Lord Sumption in that.
It's Lord Sumption in the Borough Servier. But he's there using it in a very particular sense, and that's clearly what Mr. Justice Garnham had in mind. It doesn't mean your, as it were, ground one is may or may not, may be a good point, but it's not fair to pin it on the concept of quasi-criminality, which is not really what Lord Sumption was talking about or had in mind in Laboratoire Servier.
Well, I certainly don't want to pin it on any sort of forensic pinhead or sleight of hand, but what we do submit is that the acts which arose here, the unlawful killings, do engage the illegality defence. They are clearly acts which engage the interests of the state, as Lord Sumption put it. They result in the involvement of the state in the disposal that is placed on Mr. Lewis-Ranwell. They result in him being regarded as a dangerous offender if there comes a time when he is released. And they are acts which on any view are unlawful, and as the President case puts it, excused but not justified. And where Mr. Justice Garnham may have fallen into error is that he appears to have equated turpitude for the purposes of invoking the defence, and it is usually put in the authorities with turpitude in inverted commas, but he's equated it as knowing wrongfulness. And in doing that, which he's done at paragraphs 135 and 136, he has misread with respect to what Lord Sumption was saying in apotex, but more importantly, the whole thrust and the whole holding of Supreme Court authority since Patel has been that knowledge and indeed intention are but factors to be considered. Now, there are certain areas like my Lord Justice Underhill's case, such as the employment ones, where
that was a completely different sort of case. That was just doing something the statute prohibited.
There's no doubt that in Patel the issue, the underlying point is that one has to be flexible and adapt the principle, or look at the principle by reference to the particular circumstances which arise. Yes. And the question really is whether, with respect the way it's approached in Henderson, in the various passages we've looked at earlier, I think to go back to the sort of rule-based tick box exercise, which is what Patel and Mirza were saying is not the way you should approach it.
No.
Shouldn't try and put it into particular categories necessarily. You've got to obviously have coherence. If one looks at what the judge did here, 135, in particular, he says that you must show that the claimant was guilty of quasi-criminal acts that engage the public interest, and you failed to do that. So he's being very clear about what it is you must show in this context.
He is, but I respectfully submit he's got it wrong in the sense that he's said that we must point to an act of knowing wrongfulness, which one doesn't get from the Supreme Court authorities. And he's also, with respect, we submit that we have shown and did show that these acts, resulting as they did in not an acquittal, a complete acquittal, but the special verdict, are acts which do indeed engage the public interest. That's why we have a plethora of legislation dealing with them.
You can't even say that the mens rea element of murder is missing here, because if you intend to kill somebody, you intend to kill them, that's good enough. The extra layer that's added on it by the insanity defence is that when you intend to kill them, you don't know that you're doing something wrongful.
Yes. So here we were within, the question that was left to the jury was purely the question of wrongfulness, and indeed it was common ground below that the intention to kill was there because Mr. Lewis-Ranwell intended to kill these men because of his delusion that he thought that that was his mission.
But then I don't suppose you would say that the bright line should depend on which side of the McNaughton rules an insanity defence falls, because that's a recipe for inconsistency, isn't it?
Yes, no, I don't say that, although I do say that in this particular case, if necessary,
Yes.
I have intention is present, but that's the only factor that's additionally present here. I say the other factors are enough to bring the illegality defence in. But this was a McNaughton 2 case. There is no doubt that criminal intention was present, and that's why I took the court to Loke this morning. We've set out all of this in our skeleton. The judge also rejected the application of the narrow ground, and that was at paragraph 137 of his judgment. And as I endeavoured to show from Lord Rogers' speech in Gray this morning at paragraph 78, there's certainly the case that one reason, and an important reason for the inconsistency, was the fact that this was a sentence imposed by the criminal court in Gray and indeed in Henderson. But another factor which Lord Roger highlighted, and it's the factor we see play out in the Australian case, is that this was a sentence imposed for the protection of the public. And we do submit there is an inconsistency and incoherence there from the law.
It's not a sentence,
It's a disposal. Yes. Although it's exactly the same outcome as applied to Miss Henderson, it is right that hers can be described as a sentence because it was imposed following the conviction for manslaughter. Whereas in this case, it's strictly not a sentence because there was an acquittal and it's a disposal. They both result in the same outcome. But it is nonetheless a disposal which is put in place for some of this, for a very important reason. Same reason as applies in the manslaughter cases, which is the protection of the public. And so we submit there is an inconsistency to that extent, in that, as was identified in the Hunter and President case,
So a disposal mandatory elements to it.
it's disposal which is completely mandatory. Yes. Parliament has said that there must be a it must be for life. This is the disposal that must occur, and indeed, it is no doubt for reasons like that and the reasons we looked at in the case law this morning, that the acquitted person has also got a right of appeal. I'm very conscious of the time, and I know that we've set this out in our skeleton argument, but we submit that had the judge applied Patel for the reasons that we looked at in relation to Hamblin, although they're not all on four because we don't have the element of criminal responsibility here, but we submit that actually if one looks at the reasons on applying the Patel test, one should reach the same conclusion and not treat Ms. Henderson's case differently from Mr. Lewis-Ranwell's, or vice versa. We say there would be incoherence because of the fact that the court has imposed a detention. We say that also one has to judge the question of incoherence by an application of the Patel trio test, and on an application of that test, particularly taking into account the policy in favour of the sanctity of life, one reaches the conclusion that this claim should be denied. Lord Hamblin said that was not to be looked at in granular detail because, of course, Miss Henderson in her psychotic episode was probably not thinking about criminal sanctions either. We do rely also on the public confidence test, which is our ground 4. And we respectfully submit that the judge has overlooked or not given sufficient weight to the issues. He thought the public confidence test arose only if there was a criminal conviction. I'm not going to take you to them in the view of the time. I've set out the references in our skeleton, but we refer to the fact that Lord Hoffman's reference to the fair distribution of resources has other expressions in law, perhaps most pertinently in White and Chief Constable of South Yorkshire Police, or Frost, Chief Constable of South Yorkshire Police as it's sometimes known, and it's at paragraph 29 of our skeleton, where arising out of the Hillsborough disaster, the House of Lords had refused to extend liability for psychiatric injuries to police rescuers on the basis that it would be unacceptable to the ordinary person because it might offend against his notions of distributive justice, thinking it unfair if the police could recover and not the family members. Here we do submit the public confidence principle is engaged in relation to the fact that someone is serving a lawful sentence, not a lawful sentence, but a lawful disposal, and then seeking compensation for it, the circumstances in which that disposal has come about, the fact that it is, as Lord Hamblin said, well recognised that there is an issue of resources in relation to mental health services, and that members of the public might take the view that this was not a good way of depleting them further. And I do submit also the fact that members of the public may consider the distinction between Ms. Henderson's case and Mr. Lewis-Ranwell's one a rather fine one in that respect. Which brings me also to the issue of tort. And we do say it is a surprising result if, for the purposes of this claim, tort law judges Mr. Lewis-Ranwell not to be responsible for his acts, whereas for the purposes of a claim against him in tort, he is judged responsible. And that again we submit would be an inconsistency in the law. My lady, I haven't taken you through all the paragraphs in my skeleton. They are set out there. I hope I've summarised our grounds of appeal. Unless there's anything else my lord or my ladies would like to ask, those are my submissions.
Thank you very much.
Can I just begin, my ladies and my lord, by sweeping up a couple of stray points that have arisen this morning, largely practical points. We will get you the articles. I think my junior has them now, the ones that you asked for this morning, my lord.
Yes, indeed. I see that in Henderson, I've just been looking at counsel's arguments in Henderson, other articles, some by him, some by Professor Green, Sarah Green, anyway, the Law Commissioner, and I think 2 or 3 others were referred to. I've no idea, not having seen them, how relevant they are, but they look from their titles as though they're likely to be relevant.
Well, I'll have a chat with my junior after we finish court this afternoon. We've certainly got the 2 that you mentioned this morning, but of course they're both now quite elderly, and I don't know whether Mr. Goodcamp still agrees with what he wrote in one of them.
Well, it's been put forward as his opinion. They're being put forward.
Yes, of course. And then we can have a look at Henderson, see if there's anything else we think you should have. Just on the question of what cases have been dealt with in which way up to this point, Gray, in fact, was dealt with. If you look in the judgment in your authorities bundle, you'll see that what happened was the parties got to the start of the trial. It's tab 22.
Sorry,
And
tab 22 of what?
Gray.
Gray.
Sorry, the authorities.
So sorry,
the
Gray.
authorities
So
bundle.
sorry, yes. Thank you.
And you can see from page 453 that at the outset, at the bottom of the first paragraph, at the outset of the trial, the judge ruled that since the claim was warranted and committing a serious offence, the maximum precluded recovery for loss of earnings and general damages. And that's explained in a little bit more detail at paragraph 45, page 458, paragraph 5. Paragraph 4 in his judgment, the judge noted the trial had been set down for 5 days, but on the first day of the hearing, counsel agreed he should determine on the point of principle. So it's not, in fact, a strikeout application. And as I said, Henderson was dealt with on agreed facts because judgment had been entered. Just on the effect of section 45A, so that you've got the full picture, the authority dealing with that is in your authorities bundle, but I'm not going to take you to it, I'll just give you the reference. It's Bowles, which is tab 26. But the effect of a section 45A hospital order is dealt with in Henderson at paragraph 26. And the court then goes on to look at the effect of 37 and 41, so the full panoply of possibilities is dealt with. And just out of completeness, whilst we're looking at Henderson, could I take you to what Mr. Justice Foskett actually said in Henderson at why he hadn't applied a section 45A order? So Henderson is tab 34.
What's the electronic bundle reference number?
Yeah, page 9 through 6, my lady.
Thank you.
In fact, if you go back a couple of pages to 933, you'll see that there's an appendix, which is the agreed statement of facts. And as part of that agreed statement of facts, there are the sentencing remarks of Mr. Justice Foskett, and those are at the start of paragraph 33 on page 935. And he explains, and it's on the middle of page 936. It's that mental health background that informs and largely dictates how this case should be disposed of. Quite plain that in your own interests and in the interest of the public, if and when you're released, the most important consideration is the successful treatment and or management of your condition. No suggestion you should be seen as bearing a significant degree of responsibility for what you did. Had there been any such suggestion, I would have given serious consideration to making an order under section 45A. However, on the material, that issue does not arise. Just so that you have the background on that. So my lady and My Lord, firstly, liability is denied by the Trust to Mr. Lewis-Ranwell, but we do wish to acknowledge in open court the tragic facts underlying this claim. The issue before you is a narrow but important one, whether a claimant who's killed but been found not guilty by reason of insanity to a murder charge is debarred by the illegality defence from recovering all or any of the heads of loss he claims at common law after the point of those killings. We do say, as Mr. Warnock has with the Council, that on any view we're looking at the most serious acts, and it's the Trust's position that killing is so serious that the illegality defence bars the claim, and we're fortified in that by the two passages of Lord Hamblin in Henderson, which Mr. Warnock's just taken you to, paragraph 129 and 131, and I won't go back to them. And I summarise the Trust's position thus, that the only distinction between this case and Henderson is the not guilty by reason of insanity verdict.
Can I just unpick killing is so serious that illegality debars the claim? If we were looking at some offence which did not involve killing, or perhaps any kind of injury to a person, maybe injury to property, where there was a successful defence of insanity, not often raised, but could perfectly easily happen, you would be saying that, let's assume it was arson but with no effect on life, you would say that the court would have to make a judgment about the seriousness of the offence before deciding whether the illegality defence could be raised.
Exactly that one.
Yes, I see.
And that point is there. It's there in Gray and Thames Trains, and it's also there in the.
Well, it's hinted at in Gray, but it's not resolved.
Well, no, it's not resolved. But the same comment is made in Henderson that a trivial offence. It's there in the judgment of Lord Phillips in Gray, and then it reappears in the judgment of Lord Hamblin in Henderson that a trivial offence may not engage the illegality defence, and we accept that. But the court has not so far been required to determine how trivial the defence has to be. One point which I was going to come to at the end, but I may as well come to it now. One point we certainly do reserve our position on is that before the killings, there was a serious attack on another individual, on Mr. Ellis, and the claimant was charged with GBH, but that attack was left to lie. That charge was left to lie on file because it was the murder charges that were proceeded with. And even when we get to trial in this case, we reserve the Trust's position as to what the effect of that prior GBH, if it is GBH, there was no trial, would be. Patently, it didn't lead to his detention, but we would say it was an illegal act, and the precise effects of that would need to be worked out at trial. Well, I simply part that, my lord, but there was a prior serious criminal attack.
Allegedly.
Sorry, my lord, didn't.
Allegedly.
Yes, of course. Of course, I accept the differences. There was no criminal trial. It would have to be
lies
heard.
on the file, but
yeah, exactly.
Not subject to resolution.
Yeah. We also say that the not guilty by reason of insanity defence doesn't operate as no turpitude, as the judge found, and the lack of criminal responsibility should be put into the Patel trio, and proper application of that trio leads to the illegality defence, then barring his common law claims from the point of the killings, and personal responsibility should not be a bright dividing line, which is effectively how the judge resolved this case. And we do say it would be harmful to the integrity of the legal system and bring it into disrepute to allow claims for loss which result from the conduct which led to the disposal of the criminal court, or rather by operation of statute, and from the disposition made by the criminal court following his conviction in accordance with the statute, and, as Mr. Warnock has said, under the same provisions as we used to detain the claimant in both Gray and Henderson. We adopt and repeat, well, we adopt and I don't repeat, the submissions of the Fourth Defendant, saving there's one very limited modulation, which I'll come to at the end. And so my submissions will address a subset of the issues that he's addressed in a little bit more detail. What is exactly the narrow and the wide rule? Because we say that the judge was incorrect in his formulation of the narrow rule. Secondly, do Clunis, Gray and Henderson determine the outcome, as the claimant says? The claimant's skeleton section A, precedent, paragraph 10, says it follows that on a straightforward application of this central reasoning, the draconian defence doesn't apply to insanity, so I'll deal with that. Then I wish to look in a little more detail at what is the nature of the not guilty by reason of insanity defence, looking at a couple of passages of Hunter that Mr. Warnock hasn't yet shown you, but also tying that into the academic literature. And I will then deal with that literature. And linked to that, the related question is, does there have to be knowledge for there to be turpitude? And I'll look at the cases relied on by the claimant and what I call the Trail of 5, which is the 5 cases that Mr. Justice Garnham found helpful, but which he said hadn't been cited to him. He took from the prior trailer judgment. And then turn to the application of Patel. That's a big list in the time remaining to me. I probably will do as Mr. Warren has done and leave the application of Patel to what's said in the skeleton argument, both at first instance and on appeal, which addresses the Patel test if we get to it in detail. So let me deal first with what's the narrow rule, what is the correct formulation of the narrow rule and the wide rule. The judge, Mr. Justice Garnham, says at paragraph 137 of his judgment that the submission that the narrow claim was barred under the ratio of Gray misstates the test. The narrow claim, as described in the authorities, prohibits loss which flows directly from the lawful imposition of a sentence for breach of the criminal law. And he says that here there was no breach of the criminal law and no sentence. Rather, the criminal hasn't imposed a sentence, it's simply imposed certain restrictions made necessary by his mental illness. But we say that narrow formulation is not accurate. If you look at the formulation of Lord Hoffman and Gray, and that's tab 22, page 484 in your electronic bundle. Paragraph 29, when he's defining the narrow rule, he says in its narrow and more specific form, it is that you can't recover for damage which flows from loss of liberty, a fine, or other punishment lawfully imposed upon you in consequence of your own unlawful act. And we say that's a broader formulation than the formulation.
He uses the word in consequence of your own criminal act. If I'm looking at paragraph 29 correctly. I think I am. Oh no, he says criminal act and preceding sentence.
Exactly.
Following on, he does.
So we say that that's a broader formulation of the narrower rule, and that covers the disposition by statute. That is what has led to Mr. Lewis-Ranwell's detention in this particular case. And we say that that broader formulation is also seen in Gray in the paragraphs of Lord Roger, and in particular paragraph 79, which you've looked at already with Mr. Warnock. By imposing the hospital order with a restriction, the judge was ensuring the claimant would not be free to move around in the community and until and unless authorised to do so by the Secretary of State. It would be inconsistent with the policy underlying the making of the orders for a civil court now to award the claimant damages. So again, we say that's a slightly but materially important broader formulation of the narrow rule. And then on a wider rule, that is clearly that you can't recover for damage which is the consequence of your criminal act. That's justified on the grounds that it's offensive to public notion of the fair distribution of resources. That's Hoffman, paragraph 51 in Gray. And that involves a causation test suffused with policy considerations. And you've looked at the paragraph with Mr. Warnock, paragraph 41. He referred to the variety of purposes for which a sentence is imposed in the criminal courts, including treatment, reform, deterrence, protection of the public. and punishment, it's fair to say, but he does say it would be impossible to make distinctions based on the predominant purpose. So let me move to the question of whether precedent in the form of Clunis, Gray and Henderson essentially dictates the outcome. We say that it does not. And it's important to have in mind exactly what the ratio of the case is. And there are the famous dictum of the Earl of Halsbury in Quinn and Leatham. And we haven't given you the whole of Quinn and Leatham, but it's there in the first instance judgment of Mr. Justice J in Henderson, which is tab 30, page 801 of your bundle. Paragraph 24, Mr. Moon reminded me of the famous dictum of the Earl of Halsbury in Quinn and Leatham. Every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which may be found there are not intended to be expositions of the whole law, but governed and qualified by the particular facts of the case in which such expressions are to be found. The other is that a case is only an authority for what it actually decides. And I entirely deny that it can be quoted for a proposition that may seem to follow logically from it. So the ratio in Henderson is that in the context of a criminal conviction for unlawful killing, but with diminished responsibility, the killer is precluded from recovering damages for negligence against the person whose negligence was responsible for bringing about her unlawful conduct from the point of that killing. And clearly we invite you to rely upon the reasoning of Lord Hamblin in Henderson. But the question of insanity did not arise for decision patently in either any of Clunis or Gray or Henderson. The discussion in Clunis is plainly obiter. In Gray, there is nothing which says, even obiter, that the insane claimant would be able or not able to recover. Lord Hoffman expressly left the point open. Just to give you the reference, that's paragraph 42 of his judgment at page 488. The Supreme Court was addressed upon insanity in Henderson, and that you can see that from the summary of the defendant's arguments at page 942 of your bundle.
You were there, so you can tell us.
I was there, yes. It's internal page 600. Paragraph F, or it's Roman 4. The question of responsibility in relation to insanity did not arise for decision in Gray or Clunis and does not arise on the facts of this case. Does not need to be addressed by the court. There's a danger of creating a bright line in homicide cases between claimants who've been found not guilty by reason of insanity and those who've been convicted of manslaughter by reason of diminished responsibility.
Sorry, where are you reading from?
It's Roman 4. It's between E and F
I've got
of
it
page
now, yes.
942.
No, I have it,
Yes.
thank you. Yes.
And the defendant also made the point in the Supreme Court, and this is over the page at H. Looking at what insanity might mean, is right, the final paragraph at the foot of that page. In other jurisdictions, the residual unlawfulness of an act of homicide committed by a person suffering from insanity may be taken into account when determining what consequences of such actions should give rise to civil liability and negligence. See, for example, Hunter. But we also said, nor does the respondent say that in another case a finding of insanity would be determinative of the issue of illegality one way or the other. It would be a factor to be taken into account. depending on the circumstances.
So who says that?
That was the argument advanced by the defendant respondent in Henderson. So the Supreme Court was addressed on what the outcome would be.
It doesn't really matter whether they were addressed on. It doesn't matter what they decided.
Well, but they expressed no view one way or the other
right.
on an insanity case. That's exactly my point, my lord. Yes, and what Lord Hamblin did say in the passage you've already looked at is that the question should not be looked at solely at the granular level of diminished responsibility cases. So there is nothing, we say, in the reasoning of Clunis, Gray, and the reasoning is not the ratio, and there is nothing simply in the form of Clunis, Gray, and Henderson which determine the outcome as the claimant asks you to find. So let me.
But the judge doesn't actually decide it on the basis he's bound, does he?
Well, the
Does he? Maybe I.
it's part of the claimant's skeleton argument.
There is, well, I haven't got that far. I was just saying the basis on which the judge decided.
No, he takes a fresh look. It's fair to say, but the claimant's position.
But is there a respondent's notice from the claimant saying the judge didn't decide on this basis, but he should have on the basis that we're bound?
No, there isn't. Well, I'll deal with that further if I need to. We've heard what the claimant has to say, but it is the position in the skeleton argument, as I say, that precedent binds this court. So let me move on to the nature of the not guilty by reason of insanity verdict. I adopt what Mr. Warnock has said to you about Attorney General's reference. What Mr. Justice Garnham says, and this is at paragraph 126 of his judgment, is that he's citing, in fact, Mr. Justice Johnson in Trailer against Kent and Medway NHS Social Care Partnership Trust, as you see from paragraph 123. He cites Mr. Justice Johnson, who said, "I don't accept the submission that Mark Trailer is to be treated as having committed a criminal act. The common law background and legislative history show that those who satisfy the test in the McNaughton rules are not regarded in law as having committed the act or having any responsibility for the act." And it seems that he approves that passage. But we say that passage has fallen into error. Attorney General reference, which my learned friend took you to this morning, makes it clear that an insane defendant in a criminal trial is regarded as having committed the act. It's then that he's exonerated because he has no criminal responsibility. So insofar as Mr. Justice Garnham relies on that as part of his analysis, it's wrong. And there is just one passage in the Attorney General's reference number 3 of 1998, which I would take you into in addition to those which you were shown by Mr. Warnock this morning. And it's a passage which is at page 450.
No. Which tab is it?
It is tab 21. The judgment is looking here at did the actor made the omission charge. This is between F and G. This act is obviously concerned with the same issues as the Act of 1991, which itself expressly refers to the Mental Health Act in the context of the Act of 1883. this pattern is entirely consistent with an overall framework designed to ensure, first, that those who are legally insane should not be deprived of their liberty by, or nowadays made subject to orders of the court exercising criminal jurisdiction, unless they have behaved in a way which constitutes the actus reus of a defence. So it's clear from that the Section 3741 disposition is not engaged unless you've behaved in a way which constitutes the actus reus. And I pause there to note that it is plain, therefore, that the question of whether it was lawful or unlawful violence comes before the question of insanity, and that confirms the hierarchy of defences which the Trust has set out in its skeleton, and which I'll come to in a moment looking at the academic literature, that self-defence comes before insanity. But before any, by definition, before any question of diminished responsibility or insanity, the homicide must have been done with murderous intent and without either provocation or self-defence.
Lord Judge gives an example in the Attorney General's reference of the person swimming in the swimming pool, if I remember correctly, in the indecent assault.
Yes.
And explains quite vividly how that applies.
Yes. So self-defence, either justification or excuse, come before any sort of irresponsibility defence. So, if there is an actus reus, we say there is an unlawful killing. As you said, in discussion with Mr. Warnock, it's patently not a lawful killing. It's not that the claimant killed the three men in self-defence. The killing was both unjustified and inexcusable, and then there's a full irresponsibility defence and an acquittal within the common law defence and the statutory framework. The claimant, in his skeleton at paragraph 24, and that's at page 111 of the core bundle, tab 9, states that the unlawful element of the offence does not apply where the defence of insanity is established. And we simply say that's wrong. These remain unlawful acts. An insane claimant cannot freely kill others. And if at an individual level he's absolved from criminal responsibility, at a wider societal level and at the level of the criminal law, killing is unlawful, absent a justification or excuse. And I'm then going to move to...
We don't include excuse in this case the way that it was used, I think, by Mr. Warnock, or that it was... his responsibility was excused. You don't mean that?
No, I mean
in the context of self-defence or
criminal
something like
excuse,
that.
yes. And I will look at the taxonomy when I come to look at the academic literature. And just one other point on that. Mr. Warnock looked with you at the Criminal Procedure Insanity Act 1964. And we rely on the fact that other than in a murder case, and this is section 5.3a, so less than in anything less than a murder case, where this is page 12 of the bundle, tab 3, where the court has the power to make an absolute discharge of the accused, they may do so where they think, having regard to the circumstances, including the nature of the offence charged and the character of the accused, that such an order will be most suitable in all of the circumstances. And in my submission, that is, it makes it plain that this is something quite different from a full acquittal. So I would then like to move on in looking at the character of the not guilty by reason of insanity defence, just to go back to Hunter and present. I'm not going to take you to the passages, of course, that you've already looked at. We wish to add some further submissions, however. It is directly on point, and it remains the most sustained treatment of it, not guilty by reason of insanity case anywhere in the common law world. In understanding the framework that it adopts, it's important to understand it was decided in 2005 when Gala and Preston 1991 was the leading case on illegality in Australia. And Gala dealt with illegality through the prism of duty of care, as in fact did Clunas. And we say that explains why Chief Justice Spiegelman deals with illegality in his judgment under headings concerned with duty. And Gala remained the law until Miller and Miller, which replaced the duty approach to illegality with an approach that asked whether to allow or deny the claim would be incoherent with the statute that the claimant violated. And I won't take you to it, but that chronology is set out in the extract from Clark and Lindsell that you have in your bundle. It's tab 51, page 1448, section 307, and it's headed "Impossible to set a standard of care."
Which page?
Page 1448, my lord.
Thank you.
And
That'll give us all the case references, Miller and Miller and Scala and all that.
it has, yes. And of course, Hunter predates the House of Lords in Grey, and it predates the Supreme Court in Patel and Henderson, and the terms in which its judgments accounts need to be read accordingly. And one of the listed issues, as you see from the not very satisfactory copy that we have in the bundle, one of the listed issues, and this is at page 1107, is whether the killing, and this makes it absolutely clear how the categories of consideration that are being applied interblend, whether the killing of Miss Laws disentitled Presland to recover damages under the principle of ex typi causa, or on the basis of a break in the chain of causation, or on public policy grounds. So, and we say those three, in the light of Patel and Henderson, can now effectively, and Gray, can now effectively be read together. It is clear that Mr. Presland was Macnaghten 2, and that's paragraph 292 of the judgment. He knew he was killing, but he thought he was justified. So,
Paragraph of the judgment.
Paragraph 292, my lord. So absolutely on force with this case. If you look at page 1110, the list of the cases cited, and 4 of the 5 trailer 5 cases are cited. See, looking at that list of authority, so the trailer 5.
Sorry, I'm behind.
Mr. Justice Garnham relied paragraph 130 of his judgment.
No, sorry, I got confused. I thought you were showing us a passage in Hunter.
I'm going to, but the point that I'm making is...
because I know what the trailer 5 are.
Yes, so four of the 5 trailer cases are cited by the court in Hunter and Presland. So it can't be said that these judgments were reached in ignorance of those trailer 5 cases. That's the only point I'm making.
Which page do we see where they're cited?
So paragraph 56. In Chief Justice Spiegelman's judgment. But they're all there in the list of cases cited at the beginning.
Okay, I just thought it useful to have page reference.
Yes.
I don't want
Let
to
me
say
find that for you. So page 1110, you can see that that's the full list of cases cited.
Yes, I see. Okay, thank you.
Yeah. And just to give you the reference, paragraph 56 of Chief Justice Spiegelman, he refers to the 4 cases, and the 5th missing case from that list of cases cited is James and British General Insurance. And even that case is within paragraph 233 of Justice Scheller's judgment, when he refers to Beresford and Royal Insurance. So all of the 5 cases that Mr. Justice Johnson referred to were considered by this court in Hunter and Presland. And let me just take you to 2 paragraphs in the reasoning of Chief Justice Spiegelman. At paragraph 56, although he dissents on the overall outcome, he agrees the fact that the unlawful conduct constitutes a crime is itself material. Actually, I think let me.
Which page is it?
No, I'm going to scratch that reference, my lady. I don't think it's helpful. However, these are the passages in which he looks at the trailer 4 cases. So you see at paragraph 58, Adamson and Jarvis, Hardy and Motor Insurers Bureau, and over the page, Gray and Barr, and then Pitts and Hunt. What he doesn't say when he analyses these cases is that a lack of knowledge is a knockout blow and that there is then no turpitude. And at paragraph 78, he does conclude,
Page number?
page 1124, my lady. He says that where a person is found to be not criminally
So where are you reading from?
paragraph 78, foot of 1124. Where a person is found not to be criminally responsible for his or her actions on the grounds of insanity, the common law should not deny that person the right to remedy as a plaintiff. In such a context, the unlawfulness of the conduct is not entitled to weight in a multifactorial analysis. What he isn't saying, even he in the minority judgment, is that lack of knowledge is a knockout blow because there's no turpitude. And at paragraph 82, even though he's in the minority in allowing recovery, he refers to the unlawful but not criminal conduct of the respondent. So that's the same categorisation of the respondent's conduct as we are urging on you here.
Sorry, para 82, did you say?
Yes, I did, my lord.
Oh, I see, yes, thank you.
Yep. Let me proceed then to the majority judgments. So, Justice Scheller, whose judgment you were taken through by Mr. Warnock, and I won't repeat that, but at paragraph 312, which is page 1193, as Mr. Warnock showed you, the judgment is relying on the analysis of HLA Hart, that insanity is not a justification for an unlawful act, but rather an excuse. And that analysis, the analysis of HLA Hart, is relied on also at page 383, paragraph 383, the paragraph that Mr. Warnock took you to. According to Hart, the essence of an excuse is the act may be deplored, but the psychological state of the agent when he did it exemplified one or more variety of conditions which are held to rule out public condemnation and punishment of individuals. So he's relying on exactly the same text of HLA Hart, Punishment and Responsibility 1968, which is cited by the claimant in his skeleton at paragraph 21. What he's dealing with is whether the claimant should be punished, but he is not saying the act is not wrong or unlawful. So I won't look at any more of this, but what we say is it's absolutely apparent from the judgment that it's with full citation of authority and with citation of the academic literature, and the reasoning is Patel consistent and Henderson consistent, and therefore it should be given great weight in any consideration of the insanity defence in its relationship to tort in this country. And that was not the status which Mr. Justice Garnham gave it, as you've seen from his judgment. He didn't find it at all helpful.
Yes, I think we can discern that from what he said.
Yes, yes. So can I turn then to the academic literature, which insists further on the nature of the not guilty by reason of insanity defence and how it relates to the partial defence of diminished responsibility. We could have given you a lot more than we have, but didn't want to get bogged down in it. There is a short answer and a long answer, and I'm going to give you the short answer to the question of whether there is wrongdoing in the case of a not guilty by reason of insanity verdict. And the short answer is that both Professor Hart and Professor Gardner, who we've relied on in our skeleton, say that defences of any sort are predicated on the existence of a wrong and do not extinguish it. And that accords, we say, with the analysis in the Attorney General's reference case and with the analysis in Hunter. They do disagree about how to characterise insanity.
It accords with the analysis of. I missed what you
the
said.
Attorney General reference case, my lady.
Yes, and Hunter.
And Hunter and Presland, that there's unlawful conduct,
Yeah.
even if there's no criminal responsibility. So for Professor Hart, insanity as an excuse, whereas, and that we've seen that in the passage from judgments in Hunter and Presland that we looked at, that's the term he uses. Whereas for Professor Gardner, insanity is a denial of basic responsibility. But that distinction of categorisation is irrelevant for present purposes, because the point is that an insanity defence is needed by an insane person because there is a wrong. And where conduct is prima facie an offence, as it is here, whether there's both actus reus and mens rea, and there's an absence of justificatory defence, then defences of irresponsibility can come into play, and in the case of murder, that can be either a full responsibility defence, not guilty by reason of insanity, or a partial irresponsibility defence, which is diminished responsibility. But in each case, the conduct is unlawful. So let me move to the analysis of Professor Gardner in chapter 4 of his book, Offences and Defences, which is in your bundles at tab. Chapters 4 and 5 are both at tab 46 of the authorities bundle.
Which bundle is that?
The
Sorry.
Authorities.
It's always good practice for the people preparing bundles to say on the back which tabs are in it.
Yes.
After a bit, you find your way around it. But okay, I've got it.
And what's the electronic bundle reference, please?
So it's page 1306.
Thank you.
We haven't given you the abstract for chapter 4, which hopefully you have for chapter 5, but it's looking at the tenability and importance of the distinction often drawn by criminal lawyers between offences and defences. And his view is that justifying a wrong is different from denying it. In section 1 of this chapter, page 1306, he looks at wrongdoing and justification. I won't go through it with you in detail because we're not looking at justification in this case. But you will see at the end of page 1311, the end of that section, page 1311, that justification leaves are wrong. And then in section 2, he moves to look. This is the materials section for our purpose.
So what was the okay?
That
From 1, though, were you referring us to some particular
yes.
on page 82?
Yes. So page 1311. Well, in the interest of time, let me move on to his overall taxonomy of justification, excuse, and then irresponsibility. So in section 2, he looks at responsibility and excuse. And if you look over the page at 1312, he comments in footnote 11, at the bottom of that page, on the HLA Hart legal responsibility and excuses paper, which was the paper that we saw featured in the Hunter and Presland judgments, where excuses are denials of responsibility. And he says about JLA Austin, this is the paragraph beginning, I do not know whether Austin himself endorsed the residual view of responsibility. He gave succor to it when he characterises full or partial denials of responsibility. So I just wanted to look at the full or partial denial of responsibility taxonomy, because that's the taxonomy that applies to diminished responsibility and insanity. And moving on to 1315, he embarks on the taxonomy we rely upon. What is the difference between them? And then 4 lines, he's looking at the difference between excuses and justifications. Justifications are rational explanations for wrongdoing. Surely excuses must be non-rational ones. This neglects the fact there are 2 kinds of rational explanation for wrongdoing. A rational explanation is a justificatory one to the extent that it cites reasons the agent had for doing whatever she did. An excusatory explanation falls short of this. It relies on reasons the agent had for thinking she had reasons to do as she did, or reasons she had for being inclined or inspired or driven. So that's his difference between justification and excuse. But then, looking further down that page, he says, it's about 9 lines up from the bottom. This, in turn, is where an excuse differs fundamentally from a denial of responsibility. One can imagine a terror that is not explained by any features of one's situation. One's terror is no way lessened when one has less to be terrified of. If one kills in the grip of this terror, one's left the realm of excuses behind, let alone the realm of justifications. For not only the killing, but even the terror itself is no longer apt to be rationally explained. One can only explain it as an affliction. In this process, one casts doubt most regrettably on one's responsibility for one's actions. So he's coming to irresponsibility as the 3rd tier down in the categorisation of defences, but the whole taxonomy presupposes that the wrong remains. And that taxonomy is then set out in his section 3. When he comes to what he describes as Jaraborg's ladder, and Jaraborg is another academic with whom he's engaging, you see from page 1317, Jaraborg writes, if it's important to distinguish between a deed is criminalised but not unlawful because it's justified, a deed is unlawful but not a crime because the actor is excused, it's even more important to distinguish between an unlawful deed is not a crime because the actor is excused, and an unlawful deed is a crime but the actor cannot be legally punished. And Professor Gardner says he doesn't agree with the way Jaraborg allocates specific criminal defences to these categories, because he puts mental incapacity to the excuse category when it belongs to the cannot legally be punished category. But the important thing is that hierarchy of offence, justification, excuse, and then irresponsibility. So the way that works in practice is that it's best of all if we can commit no wrong at all. If one kills, the next best thing down is to kill with justification, or at the bottom of the taxonomy is to kill with no good reason, no justification, and no excuse, but with an irresponsibility defence. But in all of those situations, the wrong remains. And so the key to this chapter is the hierarchy and the residual wrongness of the killing. Now, we've relied on 2 or 3 other articles to make good the same points. The first of those is the article by Professor Fingeret, which is at tab 45, page 1289. And he's looking in this chapter at diminished mental capacity as a criminal law defence. And what he says, if you look over to page 1295, in the paragraph that's highlighted at the bottom of that page, I turn now to discuss a fundamental conceptual confusion that's arisen because the special verdicts of not guilty and insanity and automatism are too often conceptually equated with a more usual not guilty verdict. Normally a not guilty verdict wipes the slate clean of criminal law, but a criminal slate is not wiped clean when the verdict is based on a finding of diminished mental capacity. An insane person who kills someone is doing what criminal law is intended to deter people from doing. The point here is not that he's guilty or innocent, but his radical incompetence is such that he should not be morally judged at all. So he is doing the unlawful act which the criminal law is intended to deter people from doing, but because he is irresponsible, he shouldn't be morally judged for the purposes of punishment. And we say that chimes with the Attorney General's reference case, which we've looked at, and also with the analysis of Professor Gardner. And the further piece which we rely upon is the Dressler article from 1984, which is at tab 44, page 1279.
Sorry, what page?
1279, my lord. So this is a 1984 article from the Journal of Criminal Law and Criminology. And you will see from page 1279 and 1279 that he is responding to an article by Professor Morse, who was asserting that defence of diminished capacity should be abolished. And Professor Morse's position, and this is at 1281, and you see this from the paragraph beginning, first let me lay out Morse's argument. His thesis is that actors who commit the same act with the same mens rea should on moral grounds be convicted of the same crime and punished alike. Under Morse's approach, all partial excuses would be abrogated, the defence of diminished capacity would be lost. And Professor Dressler's overall response to that is at page 1284. In the passage beginning, the paragraph beginning analytically, the problem with Professor Morse's approach is that he looks at only half of the relevant picture. He focuses almost exclusively on the harm the criminal commits. He thereby obscures the true function of excuses in the criminal law. Excuses negate personal blameworthiness. They do not mitigate in any way the harm that has occurred. When we acquit the insane killer, we do not imply thereby that the victim's life was unvalued. acquittal of the insane actor is in no way inconsistent with our deep devotion to the rights of the victim. We fully condemn the act of the perpetrator, but we conclude that it's wrong to cast moral blame on and punish the insane actor. So again, we say that is completely consistent with the analysis. There's an unlawful act which offends the prohibition on killing, but criminal responsibility then comes in to remove him from the realm of criminal punishment. And we referred further in our skeleton to an article from Dr. Luffman. The claimant has criticised our use of that in his skeleton at paragraph 25D, and I accept that the citation which we included in the skeleton argument was in fact from Professor Dressler, not Dr. Luffman herself, and I don't propose to take that Luffman article any further. But overall, we invite you to accept the simple analysis derived from Hunter, Hart, Gardner and Henderson that there must be a wrong before a defence is needed. Diminished responsibility and the insanity defence are conceptually of the same category, and the difference is one of degree. They are both irresponsibility defences, but the effect of the absence of responsibility is in not guilty by reason of insanity is to result in the special verdict acquittal. But the wrong remains even though the perpetrator is exempt from criminal liability and responsibility. The claimant has responded to that argument in his skeleton argument. Given the time, it may be better if I wait to see how that's characterised in oral submissions and then deal with it tomorrow briefly in reply.
Certainly we'd be content to sit to 4:30 unless it's going to inconvenience anybody rushing.
I'm very
for a train
grateful, and then
or
I
whatever.
can finish today. Thank you.
Because I know we did cut you down somewhat in terms of timing, so if you've got more you wish to cover in 15 minutes, then
I'll finish. Thank you. So the claimant in the skeleton argument at paragraph 24.
Oh, this is doing the task you thought you'd wait until later.
Yes.
Yep, no, that's fine, no problem.
Well, now I've got 15 minutes. I'll
No,
try and deal with it all today. Yep. The claimant's skeleton at paragraph 24 responds to the literature that we've cited. And the passage I'm looking at is page 111 of the core bundle. They've relied on Professor Semester and then Professor Hart. And I've already looked at Professor Hart, but they then say that we rely on reasoning in Hunter and Presland in support of an argument that the acts remain unlawful despite the insanity defence.
Sorry, where? Para 24?
Para 24, yeah.
Yes, I see, thank you. Yeah.
The unlawful element of the offence of murder relates to the absence of a justification or excuse and presupposes the individual has capacity to reason. It does not apply when the defence of insanity is established. And it will be evident from everything I have said and Mr. Warnock has said that we are we don't accept that premise at all. And the specific article, which is academic writing, which is relied upon by the claimant in this paragraph, is the next chapter of Professor Gardner, Offences and Defences, which is in the bundle at the it's tab 46.
bundle reference.
Chapter 5 is at page 1319, my lady. there is a helpful abstract of this chapter at on page 1319. And the claimant cites Professor Gardner in this chapter as authority for the proposition the unlawful element doesn't apply where the defence is established. And we say that's an inaccurate characterisation of his position. He does say at page 1112, and this is the next article, which is an incredibly unhelpful type. It's tiny, but page 1112 is at bundle page 1330. Now, what Professor Gardner in fact says at the bottom of this paragraph, and it's 5 lines up from the bottom, he doesn't say that there is nothing wrong or unlawful when the actor is insane. He doesn't go back on the analysis I've shown you in chapter 4, that the wrong continues, but the defendant bears no personal responsibility. He does say that those people who can't meet these conditions don't need to bother making excuses. This is the bottom of the middle paragraph. Such people are not responsible for their actions and are free from blame, as well as being improper targets for criminal liability. Irrespective of both justification and excuse, justification and excuse both belong to the realm of responsible agency. But what he's not saying is that if you have to rely on the irresponsibility defence, that you haven't committed a wrong, or that there was nothing unlawful about what you did. So we say this doesn't support what the claimant appears to be relying on it for. I was also going to look at the knowledge cases, the strict liability knowledge cases, leaving the academic literature now to one side. Does there have to be knowledge for there to be turpitude? We say no. And I would just pray and aid 2 passages looking at the relevance of case law in other areas to a particular area where the insanity defence arises, where the illegality defence arises. And it's worth pointing out that I think the Chitty chapter on illegality runs to 189 pages because illegality occurs across so many and varied a spectrum of situations. But Lord Hoffman in Gray at paragraph 30, and this is tab 22, page 484, but I won't take you to it, says that a good deal of time was spent in argument examining diverse cases and discussing whether the conditions under which the courts had held the maximum applicable in some other kind of case were satisfied in this one. He did not find it productive. And we say it is not productive in this particular case to look at the strict liability cases where the presence or absence of knowledge comes into play. And in similar vein, Lord Tolson in Apotex, at paragraph 57, says that the case law is notoriously untidy, and that where a situation is not covered by well-established principle, you have to look carefully and consider the policies. So that's what we urge you to do in this case, and we say that looking at cases from a completely different factual situation, for instance, the strict liability cases or the trailer cases, is not going to assist. And the case we come back to then that will assist is Hunter and Presland. Just looking at what Lord Sumption said about the strict liability cases and the presence or absence of knowledge, he was talking about only strict liability offences where the claimant's not privy to the facts making his act unlawful. And Lord Hamblin in Henderson at paragraph 112 endorses that reading. He says the reservation made in Gray may be an example of such a case, as may be strict liability offences where the claimant's not privy to the facts. So you can't simply transpose the knowledge requirement in a strict liability case into this context. And so we say generally about all of those, the Trailer 5 cases, that the Hoffman warning applies, and with all the more force where they precede Clunis, Gray, Patel and Henderson, as they do. And as we've pointed out in our skeleton, none of the 5 were relied upon in Gray, Apotex, Patel, Henderson or Stoffel. There's a fleeting reference at paragraph 102 to one of them about the relevance of taking into account the statutory context, but that's not the situation that we're in here. So they don't amount to a line of authority which will assist in the present case. And they are on wholly different factual situations. And we say the same applies to the authority which Claimant is now relying on in their skeleton at paragraph 35b, Strongman and Sincock. It's an entirely different set of circumstances and it simply doesn't help. So I was going to come then to Patel and the application of Patel. I have dealt with that, or we have dealt with that fully in the skeleton argument which you have for the appeal, but could I also give you the reference, you've got them in the bundle, to the skeleton at first instance, which also dealt with Patel. Let me just find the reference. So the Trust's first instance skeleton is in the supplementary bundle at page 218, tab 13. And there is a detailed analysis in that skeleton of the application of Patel by comparison to Henderson. So obviously I won't take you through it, but I think it's a helpful summary of why we say that the outcome should be the same as that in Henderson once Patel has been applied. And just finally then, we say that the fact that the claimant is being held by the operation of the statute, it's not at the discretion of the court, by operation of statute under section 31, and that under the narrow rule he would be awarded damages for his lawful detention is a magnetic factor in this case. The claimant can point to no case where a claimant has been awarded damages for lawful detention, which would be the effect here. And you've seen in Hunter and Presland that Chief Justice Spiegelman refused to award general damages for the lawful detention. And as we've pointed out, Henderson and the claimants in both Henderson and Gray were held under the self-same provisions. So that would create inconsistency and incoherence to give Mr. Lewis-Ranwell damages for being held under section 37 and 41, where the law does not give them to Miss Henderson and Mr. Gray, particularly because it is by operation of statute. Now, the one reservation that I said I wish to make, and I will make it and then finish, is that one factor that is prayed in aid in Patel by other defendants is whether the victims could succeed, said that they couldn't. And that's in the First Defendant's skeleton at paragraph 51 and the Fourth Defendant's skeleton at paragraph 31. The claimant takes issue with that. And I wish to say that the Trust is not, it is not the Trust's position that it's inconceivable or absolutely impossible that a victim of a third party could establish a claim in damages against a body who'd failed to stop him. There would have to be, for example, an assumption of responsibility in highly specific circumstances, and it would be a formidable hurdle for a claimant to overcome. But I don't wish this court to proceed on the basis, which I'm sure it won't, that such a claim would be utterly impossible. And that links to the question of indemnity. The claimant seeks an indemnity against possible claims by third parties. As Mr. Warnock has told you, none have been brought, and we're now more than 3 years from the incident, the GBH or putative GBH and the killings. But if the illegality defence weren't to apply, I just wish to make it plain, it doesn't follow, we say, that the claimant would be entitled to the indemnity seeks against third-party claims not least because that would possibly cut across with the law on duty of care, and that would have to be a matter left to the child judge. So it doesn't follow, if the illegality defence didn't apply, that the indemnity he would recover the indemnity. So I'm informed that we have the articles that you asked for at lunchtime. And we'll have a look overnight to see if there's anything else we can helpfully give you. Is there anything else I can assist you on for 28?
No, thank you very much. I'm very grateful, obviously, for all the work that everyone's put into this case, and we look forward to tomorrow.
May it please you, my lady, my lord. I won't be detaining the court with further submissions tomorrow. I'm endorsing and repeating and adopting the comprehensive submissions of my learned friends, and I'm alive to the claimant probably being beneficial for her at a clean start tomorrow. So that would complete the defendant's
You're adopting
suite.
what might be called the second defendant's position. In essence. Right.
If the articles should just be put up after we've risen on the bench here, my clerk can pick them up and pick up the rest of my papers.